Yes. On the list.
My lord, may I have a leave to file an appeal without certified copy, my lord, but with server copy?
When was the order passed?
My lord, 22nd April.
You didn't get it?
No, my lord. I applied it.
For inclusion by application.
Mention on Monday with notice. Monday and Thursday mention. Yes. Yes, call the list.
Lordship, may I permitted to leave the matter without certified copy for file a case?
Pardon?
May I permitted to leave to file a case without certified
When
copy?
was the order passed, madam?
24/4 to 2025.
When did you apply?
25 April.
Leave granted. কল করে যাও একটা ফার্স্ট কল দাও
Well, I appear for the respondent on Calcutta.
yes first call we are coming
I am appearing for the appellant. I am led by Mr. Siddhartha Banerjee, my lord. There is a difficulty. Mr. Banerjee is not present in court today, my lord. Kindly may it be fixed on Monday or Tuesday, my lord, any day.
My lord, I beg to appear on behalf of the respondents.
it cannot be Monday, it will be next Thursday.
My lord,
Yes,
deeply.
Your Lordship.
or not Thursday, then it will be Monday week. Yes,
Your Lordship. Item number
Monday
1.
week.
then 13th করো 13th. Yes,
Fixed time for the appellant.
6th. We are coming back just now. Yes.
But I appear on behalf of the parents.
Yes, Mr. Sengupta. This is that matter.
Yes, which your lordship is supposed to defer because it's only academic now, because we can't give anything, they can't get
We
it.
keep it in the monthly list. Monthly list করো. Yes, next.
Well, in 12th, I appear for the respondents. This is the appeal. Mr. Jana is appearing. Court, they filed the appeal, and he's led by Mr. Dr. Maloda Kishore Dr.
You are for the vote.
I am for the union, representing the members.
Let us take the first call. We are coming back. Yes,
I'm for 11. Item number. This is 11.
you are coming back.
Right,
You are
right.
coming back. Yes. Yes.
Your Lordship. In item number 1 and 2, Your Lordship. Item number 1, the advocate on record for the appellant.
Why you are praying for adjournment? sir?
If it could be taken up, I am not in the matter, Your Lordship. He is just Sumitabu Chakraborty. He's the advocate on record. He's just gotten married, Your Lordship. If it could be taken up on Tuesday or thereafter, he's the advocate on record for the appellant in item number 1. Out of the same order, item number 1 and 2, 2 has been filed by the other side, Your Lordship, where I'm the
May. Yes. 14th May.
Yes, Your Lordship.
Item number 3. देखिए 3 14th May করে দেবে
No, 1, 2.
Well, 4 I appear for the Kolkata Municipal Corporation.
3টা 14th May করেছো 4. Yes, Mr. Ghosh. You are for the appellate.
No, I'm for the Kolkata Municipal Corporation respondents.
Who is your other side?
On the other side, my lord, I find the name of the advocate on record is Gautam Das.
এই to file টা দাও
It's another construction, my lord. There's a directions for demolition of the additional, my lord, number of floors. My lord, we, the court, my lord, pass the directions, my lord, the police to get the premises vacated so that we can, my lord, go and for demolish the building. The direction order has been passed by us.
So you had given a free hand, Mr. Ghosh.
No, I have been given free hand, but the entire the unauthorized part is occupied by the persons. Therefore, they are to be removed. The court also directed the police authorities to get that premises vacated. We have been going. Police is coming, but the thing is this, my lord. Still now the premises in occupation. There have been an announcement for the persons to come out, but they are not. I have got a report, last report, my lord, from the authorities, my lord. The part, but the vacant part has been demolished.
देखिए, दाও। So what remains in the appeal, Mr.
Well,
Ghosh?
this is not the appeal. It's a public interest litigation.
This is a public interest litigation.
Yes, my lord.
Then we don't have the determination. Public, এটা কি public interest litigation?
Security modus করছে। Extra দিয়েছি যে এটা for security advantage.
Possibly, my lord, it's a group 9 appears so.
Pardon?
It appears so, my lord, the mat number is a group 9 appears to be so.
So now what remains in the appeal?
But it remains, my lord, your lordship has been.
It's a contempt of court act.
ও CPN আছে না?
আবার MFU আছে।
Yes, অনেক লোক আছে তো।
Contempt appeal, contempt order থেকে appeal।
আফজালুর রহমানটাকে against an order in contempt.
বোঝার চেষ্টা করছি কি না।
বছর আগে সব অর্ডার দিয়েছে পেন্ডিং What is your allegation? Your police is not providing assistance.
Police is coming, but they are not standing, my lord. They are not taking out the persons, my lord. The photographs are, my lord, should be lordship that what is happening in the locality. The photographs are there.
Where are the photographs?
The report which I have given to lordship, my lord, that
This report is of 16th of April.
April 2025, the certain photographs have been attached.
No, there was an order way back in 30th of April that the court directed that these persons are in hands in gloves with them. You were directed, your commissioner was directed to disclose the name of all the officers.
Kolkata Municipal Corporation.
Yes,
Well, possibly,
there was an order way back on 30th of April 2024.
possibly that was done. Well, let me check it up.
বুঝেছো? কি হয়েছে তার অর্ডারটা করে দিয়েছে তারপর তো ফলো আপ করেন।
Oh, I filed that already.
Hmm?
I filed it already.
Where is that?
That is in the file, possibly 6th May 2024.
26th?
6th May 2024.
Affidavit to file forward. This affidavit by Dhawal Jain, the municipal commissioner.
Affidavit on behalf of the municipal commissioner.
Yes, 6th May.
Moinak Bosch is appearing for the petition of it. I find.
Keep on doing that.
Hmm? Which vacant portion you have demolished, Mr. Ghosh?
Well, I have stated, my lord, that on the top floor, certain portions have been demolished, but the police subsequent.
Nothing is there. Is this a report? Is this a report? You have gone through it, Mr. Ghosh.
I've seen, my lord, that details
But
report.
what our report is this?
They said the certain portion which are vacant that has been demolished. Only
No,
that is.
this will not serve the purpose. It's a serious issue. High Court has directed, the chief has passed an order, even has issued directions towards issuance of disciplinary proceeding upon these officers who are in
that
hands
was-
in
that
gloves
was-
with them.
after that, my lord, the court asked, my lord, this situation, my lord, to explain. After the explanation was given, my lord, subsequent order has been passed, possibly, if I'm not wrong.
We are not satisfied with this report. This is a crap of document place, Mr. Ghosh. Go through it. Are you satisfied with this report?
Well, I'll look into it, take it up some other date, my lord, that I'll, my lord, have a talk with my officer and see that with reference to the orders of the court were passed earlier.
There should be some deference to the orders of the court.
Right.
He says that I have broken a window. Finished. Sir, what is the particulars? How many rooms are there? How many floors are there?
The floor plan,
And
that is in
day
the,
before yesterday,
Well,
we have
that is-
suffered such a
well,
terrible
that is in the
incident.
order itself. The order, my lord, demolition order has been passed by us.
Yes.
That, my lord, says, my lord, that the additional 5 floors.
So if there are additional 5 floors, tomorrow if an accident happens, like day before yesterday, who will be responsible?
That is the reason the court directed for demolition. We have been taking steps. But
That
the
was
thing-
in April 2024, Mr. Ghosh.
Well, that's true. But the thing is, the persons in occupation, though are not, my lord, coming out, or the police does not, my lord, is unable to, my lord, those persons to get the
Police is unable.
No,
Police are
police, if the police, my lord, cannot, then I cannot, my lord, demolish that because I have not the infrastructure to take out the persons in occupation of the property. Time and again, the court is passing, the
Where
court is
is
also.
that you have requested the police authorities that I am going? You have said that I have demolished from 3rd of April to 11th of April. Show us one letter that you sought for police assistance.
My lord, let me see, my lord, whether the papers are with me right now.
ভাজলামও দেখো ওরা বলছে 3-4 থেকে 11-4 করছি।
Well, the document, third page, the document I have handed over, third page to officer in charge, Korea Police Station. That is 28th March 2025. We have issued a notice under section 412(2) for that, it is vacated.
Mr. Ghosh,
My lord,
by Tuesday you have to come with a comprehensive report.
My-
We are not satisfied with this report.
very good, my lord, my lord.
Tuesday it will be top of the list, and we will upon hearing you we will see what steps can be taken about your police and your corporation officials. This is really ridiculous. 3rd April to 11th April they say we have undertaken the demolition procedure. Which room has been broken by them they have not stated. This assistant engineer, your commissioner is involved and your assistant engineer is giving a report. এটা 13th top of the matter রাখবে 13th
Well, instead of 13, any other date, my lord, because 13th and
who will take the responsibility, Mr. Ghosh, that tomorrow an incident will not happen? You are also not aware about the present sequence of facts. You are also not aware, Mr. Ghosh.
day-to-day information is very difficult on the part of the lawyer to take the information day-to-day basis, but I can take the report as and when asked for the report which comes to us, I can assist you also with that.
You are our officer, Mr. Ghosh. You see the report, Mr. Ghosh, is a ridiculous
Lordship,
report
I
has been
appreciate.
filed.
Lordship may pass any order, but the thing is, we being the lawyer or the officer of the court, how way we can assist? We can, my lord, ask the officers to submit a report or to whatever the information.
That is why we are
getting,
telling you, Mr.
we have to
Ghosh,
intimate to your lordship.
please see the report. Please read the report. Just apply your mind
Now,
for
it is, my lord, what is thinking methodology? The report has, the junior has communicated them. They prepare the report and hand it over. They had not occasion, my lord, to had a discussion with me so that I can, my lord, assist them to how to order to be passed.
So
Now,
whom-
I get the from the bench, my lord. Now I'll take the responsibility to, my lord,
please take the responsibility. Call your officers.
and I'll call, my lord. I'll call
Unless
them.
you become vibrant, people won't work.
My lord, this is very difficult. The situation of earlier, my lord, has changed already. But it takes a while.
Mr.
Instead of
Ghosh, we have seen you appear for in KMC for decades, and court relies upon you. You being an officer, if your assistant
well,
engineer
the
has
changes, things have
you
already
are
changed.
saying
That I am repeatedly submitting to your lordship. That the situation which your lordship has seen the 5-10 years back, my lord, it's not the situation right now. Everything has been changed. The assistance which your lordship is requiring me with the having discussion with the officers, that is completely gone.
very good, very good. We
Therefore,
are,
my lord, I will try because, my lord, so long I am here. Of course, to my best capability, I will try to assist your lordship.
yes.
My lord, this was not seen by me. I was just, my lord, reading it after looking over the papers. I request your lordship instead of, well, because one matter is fixed, my lord, at the
Tell us when will you come on Wednesday?
Wednesday, lordship. Wednesday.
Please make it a
I'll
point
look into it.
and come with a fresh report on that date, and we will pass our necessary orders on that. No one appears today on behalf of the
Yes.
I am for the respondent.
Is not possible for me. Situation as the two panel system.
This appeal arises out of an application grant of probate. I'm challenging that. Kindly permit me to place the judgment, my lord.
एक अति यूट्यूब की Mr. Yes.
Containing the will.
Page 90.
You are for the respondents.
My lord, may I place
Page,
judgment, my lord?
page
90.
92.
in the first paper book.
Yes, paper. Second paper book is only, my lord, the will.
Will is
Contains the will.
Yes.
This is a petition for grant of probate.
You are for the heirs of Santosh Lal Shah.
My lord, I'm
Objective.
yes. My lord, I am challenging the probate. Probate has been granted.
Now, what are the relationship between you and the Tapoti Shah? Your
Okay.
sister.
Sister, right? Sister. Okay.
Yes.
My lord, at the very outset, my lord, of what I am submitting is this. So place the facts, indicate my points, and then place the judgments on the next week.
Next week. No. Please finish it up.
Today is Friday.
Yes, yes.
On Monday, I shall finish.
We don't know when we will be able to reach. This is
On
a.
Monday. It will not take much
We
time.
will again forget, Mr. Ghosh. You go for a one. You tell us you finish at one go, Mr. Ghosh. It
No,
is
my lord, I shall place the facts.
because we will again forget, Mr. Ghosh.
Place the facts and the evidence. No doubt. And on
We
the
kept this day for assignment so that we can finish at least some assignment. Our problem is, Mr. Ghosh, we have some assignments sitting with my brother Justice Chatterjee. It was a long going when suddenly it has been changed. We are in a real fix. If you are not in a position to complete, Mr. Ghosh, then
no, my lord, so far as the facts are concerned, I shall place all the things, all the facts and the evidence.
it will go beyond vacation then, because we will partly hear you and
Monday, my lord, it will be.
yes, which is your matter? Which matter? Both sides are here. Assigned matter. Yes, which is your matter?
9.
Huh? Repeatedly mentioning item number. This where is Mr. Sen? He was just now in the morning telling us.
9 probably Dibyendu Chatterjee, my lord, the বলবে তো বলো
Then Mr. Ghosh, you come on another
My
day.
lord, for last, there's 4 or 5, I don't take evidence, my lord. 5 time adjustments was
But
paid
I'm
for.
coming every day, matter is
I'm
not.
not, Mr. Ghosh. The property has been transferred, not like this. It's a vacant land and somebody has take possession of this and the property will be ruined. For the purpose of my lord, that is why your lordship was sitting in that building, my lord, your lordship was pleased to direct the.
I don't know, Mr. Rai, we are not responsible.
No,
This was before another bench. We have
That is-
been the unfortunate ones to whom it has been assigned.
And this has been assigned, my lord. This has been assigned.
নতুন সেনের কারবার নিশ্চয়ই ওটা। এই যে, এই যে, এই যে, এই যে।
Matter was taken up by your lordships, my lord, when your lordship was sitting in the
That
other building. And at that time, my lord, the
I will time for me to go home now.
that time the will be
Time.
at that time, my lord, the copy of the will was not there. That's why, my lord, matter was
So
adjourned.
matter was heard by Justice Sen. His lordship was pleased to release. Then we were the unfortunate persons whom this was.
was in the matter,
On personal ground, my lord.
personal ground. Was the matter. His junior Bubai Roy, that's advocate on record, my lord listed. Bubai Roy, his junior.
My junior is also there. I will also. কি করবে বলে তো কবে রাখবি
Mention that.
11টা বছর সারাদিন শেষ করতে হবে। Today we kept it for the assigned matter so that we can at least make an endeavor to
There is another bench, your lordship.
second half also there is another.
First half, my lord.
1.5 ঘন্টা তো লাগবে।
Hmm?
1.5 ঘন্টা তো এমনিতেই লেগে যাবে আপনার।
লাগবে এটা।
Then let it be on Monday. Let us see how we proceed. It will.
Monday, my lord, at the top, my lord. Also.
Monday will be
Monday at the
monthly.
top.
It will be on Tuesday. But Mr. Ghosh, please you finish, bring the judgments. If possible, you give us the judgments. We will also do some homework. We can be bit ready and come back.
We are also having a, if your lordship wants, I can supply the.
So please supply the documents and please, Mr. Ghosh, what are your judgments you can give us? At least we can make an endeavor so that we can all together
yes.
finish off the matter.
Or, my lord, for your lordship's convenience, may I submit a written?
Yes.
No, we want written notes. We are not wanting. We want to hear you and we want to pass.
Some
You please, by Monday, Mr. Ghosh, at least if you can get the judgments as it is the first matter, you can share the judgments with Mr. Roy and give us a copy of the same so that we can also prepare ourselves. And whenever the matter is list, we will.
Tuesday, your lordship is followed from your lordship is on Tuesday. Some precedents, my lord, only pay me because
Tuesday, not Tuesday.
my lord.
It is the first matter in the assigned list.
Yes. No, my lord is subject to my lord.
Tuesday.
Tuesday, when. No.
You want it on any other day?
No.
Then
Any day.
let it be there on Tuesday. Let us. Yes, next call the investment.
It will be on Tuesday.
Yes.
Order হবে নাকি না কিছু?
7 নম্বরটা তো ইয়ে হয়ে গেছে, 8 নম্বরটা করো।
Item number 8, I am for the
Yes.
laid by Mr. Shivaji Kumar.
Huh?
I am laid by Mr. Shivaji Kumar.
Who?
Shivaji Kumar.
Where is he?
He is saying his code number.
It will go in the monthly list. Monthly list করে দেবে। Yes, 9.
This is the
Yes.
9, I am for the petitioner respondent.
Yes, Mr. Tell us what is the matter.
everything is good.
হ্যাঁ দিচ্ছি দাঁড়াও As per your lordship's direction, I prepared a list of dates. The matter. আরেকটা দিচ্ছি দাদা।
Paper book নেই? There is no paper book in this?
No. No paper.
There is an order of this Honorable Court that the application for appropriate order is treated as paper. Probably one of the subject to correction that the order of the Honorable Division will get it by the court. Granting stay of operation.
না কপি নেই গো দাদা। আমাদের আমি খুঁজছি নেই। copy নেই। তোমাকে দেয়া হচ্ছে হারিয়ে গেছে নাকি?
Application for appropriate order.
The order of stay was passed on 22nd January 2020. This is order dated 22nd January 2020.
Before the seeing the facts.
You are, Mr. Jana, you are for the school. Acha, just give us what is the matter? Tell us the story first.
Just melody. His father was a group D staff.
Group D staff.
In the school, present school affiliated with also, with the melody only providing government DA to the approved staff. With the DA getting issue. The other financial benefit is not given to the school. Only whose service has been approved, they are getting DA from the state. Otherwise, so since the DA getting schools, there is no provision so far. I find there is no provisions for competition, either in the rules or the scheme. The management rules power has been given under the rule.
No, then what happened? He came to the court for compassionate appointment.
Compassionate. This is before Lordship's melody.
The son of the deceased employee. Deceased employee was a group D staff in a DA getting school. Approved staff in a DA getting school. Very good. Now, when did he expire?
Expired melody 21st October 1996. Well, the facts of the case before my
Judges. happened? 21st October 96 he expired.
Expired.
Now the son is before us.
And applied
Uh,
20th February 1997.
that is Lalji.
Lalji.
Yes.
He applied on
20th 20 February 1997.
1997 applied.
If your losses already understand also placed this list of the if your losses consider also I have put here.
Then what happened?
Then
তাহলে একটা কপি দিও ঠিক আছে স্টেট একটা কপি চাই
then melody he came to this honorable. This honorable court melody next page. Also page number I have in my application first.
To consider. Who was directed? DI.
Yeah.
So you were asked to submit documents.
Yes. Submit documents. Your lordship will find
If permitted under
permitted under the extent. So that is the DI of.
very good. Then what happened?
Then again he came to this honorable. Moved the report.
DI was directed to register. And if he refused to give reasons, so Mr. Jana, how did the DI enlist? On threat of contempt, you are saying, but DI enlisted him under a roster maintained for what? If there is no scheme for compassionate appointment in a DA getting school, then where from he will enlist the name?
Just you also page 61 of the stay application. What is the exactly DI say? Page 61 of the stay application. That is the page 3 of the list of dates under the second paragraph.
First of all, kindly consider page
Are we
57.
will come?
Yes.
Please, let us understand, we will come. So he said enlisted. No, we will go to page 61. Now he was enlisted. Now on 26th July, what happened? Court in contempt shall be forwarded for the post of clerk in the school.
In the school. Actually, his claim for the post of clerk.
Very good. So court directed that forward his name for filling up. Directed whom in contempt?
District Inspector of School.
In contempt directed DI to forward.
That is in contempt proceedings.
Post of clerk. Very good. Then what happened? 6/8/2003 কি করে? CIC info has already been filled up. So no vacancy.
Only one post of clerk was lying vacant, as per the DI's orders, he is still now working. So there is no second post of clerk.
So now DI said appoint him in a post of Group D by an order of 12th of January 2004.
Page 66, ma'am.
That is page 66.
Yes.
In vacancy of
In vacancy of clerk. Then it was not done. He preferred a writ petition. Then what happened? June 2009, thereafter?
2009, this is the melody order passed in 2009.
Let us show that order. In any order was passed in the writ petition. This June 2009 writ petition?
No.
Huh?
There is a direction for filing affidavit and melody matter.
Then against which order appeal has been filed?
Page, seeking the appointment.
Page 102. This is the impugned order dated 16th May 2019.
102.
The order impugned dated 16th May 2019, my lord. Of the stay application.
This was the order passed in your
2009
writ petition.
Yes, 2009 writ petition.
So order passed on
16th May 2019. তোমার কাছে কপি নেই আমার কাছে তো আছে দেখো তো হ্যাঁ
So against this order, the appeal has been filed by the school. That is before
Not
us.
against this order. Final order page 109, 19 June.
Acha, we will come to that. Then place this order.
19 June, yes, yes.
19, first order melody 16 May 2019.
So final order is
19 June 2019.
100
Page 109.
109.
very good. Then give us 2 minutes time. We will go through this order.
Yes, yes.
This is the order.
Yes, yes, yes.
29th April 2004. It is come out of Acha, where is this, Mr. Chatterjee? Where is this order of 29th April 2004? Third line of the
Page 43 of the stay application.
page
43 of the writ petition. Stay petition. 43.
This order was passed in contempt.
No. They have filed the modification application. That modification application also dismissed.
No, this why this order is not there in the list of dates, Mr. Jana?
29 April.
Huh?
29 April.
ওইটা আর দেয়নি।
School preferred an application for modification against the order.
A modification of which order they wanted?
Modification of the order dated to 22nd July 2003. 22nd July 2003. Against the order passed in contempt jurisdiction. 22nd July ডেটটা দেখো কোথায় কোন পেজে আছে and in the second paragraph it is আমি লিস্টে দিয়েছি তো সব and kindly look to page 44A. Yes, sir.
Where is the order of 5th October 2005?
Just a minute.
That is page 44.
40?
44A,
Type copy 44.
the dismissal of modification application.
And 29th April 2004 is page 42.
42. 43. And type copy is there 43A. (43A) it is mentioned, second paragraph. If the application fails,
Yeah,
then
Judge, I will complete
yes,
this.
yes.
You have gone through the facts. We are first time going. Please give us 10 minutes time. What is your age now?
Page 57. 58, 57, 58. সে কোথায় আসেনি?
Is 29th of April 2004 order at page 43.
43.
That is the order passed in contempt. Where was the parent order? The order against which the contempt was filed?
Second. Just. এক মিনিট দাদা আমাকে একটু পুলিশ না আমাকে দেখতে দিন নাহলে আদারওয়াইজ আমি পারবো একটু দাদা 29 January 2002 57 page 57
57.
page 57 29 January
No,
2000
no, Mr. Chatterjee, either of you please take us through the orders, na?
kindly follow my list of dates.
Your list of dates?
Yes, I have filed.
This one?
No, another one.
He has also prepared a
Oh, Mr. Jana, we will listen.
Yes. Kindly see, on 21st October 1996 the father died. The first application filed by the petitioner, which is at page 38, on 16 November 1996. Then kindly come to next page, 20th February 1997. The respondent number 1 petitioner submitted another application for registering his name in the life register of the died in harness category before the DI concern. On 31st March 1997, the respondent number 1 petitioner issued a letter in favor of the district inspector of praying for appointment of the petitioner in the place of her disease. Now, in first writ petition was filed in 1997 by the mother of the respondent number 1 herein. The widow of deceased employee filed the first writ petition in the year 1997, seeking appointment in favor of her son.
Very good. Now, court directed consideration.
Consideration within 6 months, 6 weeks.
Now, 12th March 1998,
Date
was
98.
this order.
Pass the order that petitioner has to file specific application for consideration of his case.
Please show us this order.
Kindly 52. Kindly look to page 52 once.
This is 12th of March 1998
Yes,
order.
yes. 50 and 50. This is the order. Type copy is there. 50A. November 1997. This is the order directing the DI to consider the case of the petitioner within 6 weeks. Thereafter, the DI concerned.
Just.
না সেটা DI এর অর্ডার, আমি আস্তে আস্তে বলে দিচ্ছি তো। ঠিক ঠিক।
না 12th বলছি 12th March 1998
Page 52 53 passed by the DI concerned.
Any type copy is there?
No. Kindly see that.
Please. Configured on the basis of the writ application as a representation of the petitioner, Sri Lalji Upadhyay, that necessary papers are required to be submitted to this office by him in due course through this for registering if permitted. So, Mr. Chatterjee, let us read 5 lines from page 52 bottom.
Yes.
Again, it is considered on the basis of the writ application as a representation of the petitioner Lalji Upadhyay
That necessary
papers are required to be submitted to this office by him in due course through the school authorities for registering his name in the died in harness category if permitted under the existing rule. So, DI ordered that you submit a representation for further consideration. If permitted under, then what happened?
I submitted the document in terms of the direction of the DI, non-consideration. Thereafter, I filed first writ petition in the year of 1998.
In the being aggrieved and dissatisfied with the order passed by, so you challenge
the order.
আচ্ছা,
Kindly see page 57 once. This is the order dated 29 January 2002.
এখানেই বলে দিতে। 29 January
2002, which is at page 57.
I cannot accept the order of DI to the, I
Yes.
direct the DI to
Register the name.
concern to register the aforesaid application and deal with the same as if the same was made with the time. This shall be done within a period of 8 weeks from the date of communication.
If for any reason the same is refused, then
Huh.
reason must be communicated to the petitioners in writing.
Very good.
Then
what
kindly come
happened?
to page 61, next page.
This is a page 61 is
The order,
Compliance order.
compliance order by the district inspector of school,
this is page 5th February.
5th February 2003.
In respect the undersigned that in compliance of the solemn order,
Order dated 29 January 2002 by his lordship the Honorable Justice K.J. Sengupta, as his lordship then was, in WP number such and such, the name of Lalji Upadhyay, son of late Gauri Shankar Upadhyay, ex group D staff of Sri Maheshwari Vidyalaya, was enlisted in died in Harness register for consideration of appointment in compassionate appointment.
where কোথায় in
His
compassionate
name will
appointment?
be forwarded, his name for consideration of appointment in the post of non-teaching staff
Of any DA.
of any DA getting school, and when opportunity will available.
His name will be forwarded for acha against this contempt.
Contempt. Contempt. In contempt jurisdiction, there is a order dated July 22nd, 2003.
Come to the last. It is recorded that petitioner's
It is
name
recorded
has
that the
been
petitioner name
registered
has been registered in the category of died in harness
for
for
employment.
employment.
However,
it
this
has
has been registered with a
prospective
prospective
effect,
effect.
not in terms of and spirit of my order. It is seen that the
What
post
was the order? Not in
Order
terms
dated
of- they were
29 January 2002.
হ্যাঁ, আচ্ছা, বেশ
I direct DI consent to register the application in aggregation and deal with the same, and if the same is made within time.
if an application আচ্ছা, I direct to register in accordance with law and deal with the same.
Same
হ্যাঁ।
was made within the time as mentioned.
So why does the court say that it is seen that this has been registered with a prospective effect? So when was the court's order? Court's order was
29 January 2002.
57.
Page 57.
29 January 2002.
Yes.
And it was passed in 5th February 2003.
3.
So why the court says that not in terms of spirit of my order? It is seen. Why,
And
why?
it is seen that the post of clerk still vacant in the said school, concerned school, and it would be open for school authority to take a decision whether the post should be filled in or not. If the post is required to be filled in then the intimation shall be given to the district inspector of school, and the petitioner's name shall be forwarded for filling in the post after taking preliminary examination and test of the petitioner as to his maximum suitability, minimum suitability.
School intimated.
Therefore, the matter is adjourned for a period of 4 weeks for the time being. The personal appearance of the district inspector of school is dispensed with until
School
further order
intimated, next
to
page,
this court.
Next page, school intimated, page, next page 64.
So the direction was upon school, was upon DI.
DI.
No, it will be open to the school authority to take a decision. Acha, then to school took a decision. That is next page. Acha, page 64.
64. 6th August 2003.
Herein received as terminal benefit during course, it is represent that one post is vacant.
One post is vacant in this school. In
No
this regard,
vacant post.
approval now, no post is vacant in our organization.
Then
Thereafter,
So next page, that's the enclosure, that the approval of the DI in favor of another person. Post has been filled. That was in 20.
was approval from which date? His clerk is Robi Binani.
another person. August 2006 or 3 or whatever.
Very good. Then what is page 66? 12th of January 24, what happened?
12th of January 2004, the district inspector of school issued a memorandum saying that in compliance with the Honorable High Court orders dated 22nd July 2003, 29 January 2002, by His Lordship, the Honorable Justice Mr. K.G. Sengupta.
No, what is 22nd July 2003 order?
22nd July 2000, 62-63. Page 62 and 63.
His Lordship considering the geo of such and
Such is hereby requested to appoint Lalji Upadhyay immediate intermediate SC, son of late Gauri Shankar Upadhyay, ex-group D staff of the school on compassionate ground in any vacancy of his school, preferably in the vacancy of clerk. Chapter contempt order 64.
Where is this memo of 16th October 87? Have you brought it?
Yes.
12 October?
School kota
12th of October 87.
Yes.
Doctor?
And thereafter they filed the modification application. That was also dismissed.
Melody, copy melody.
ওই সার্কুলারে this is not in relation to a DA getting.
True.
No, in supersession of kindly may I
এই এটা
take
দিয়ে
back
দাও।
this? হ্যাঁ ওইটা চলে গেছে কি
Yes, in
kindly see
supersession. Para 2.
para 2. The undersigned is now directed by the order of the governor to say that the governor has been pleased to order in supersession of all previous order in this regard that the appointment of compassionate ground on the of the wards of the teacher, non-teaching employees of all recognized non-government educational institution under the director of school education who dies in harness
All recognized non-government educational
institution
DA does not come within that. কোত্থেকে আসবে DA কে কিছু?
who died in harness be brought under a single umbrella. Kindly see.
আচ্ছা, then what happened?
Thereafter, the school authority filed
Now
modification.
the question is not of entitlement now. Question is court contempt order has court directed. Why have you not done so?
They filed modification application thereafter, after the recommendation of the district inspector of school. Page 64. Kindly look to page 43 once. The 43 of the stay application.
We are in page 66.
66, 43. But annexure, they prepared the stay application. They know. Page 43, 43A.
Yes.
Kindly see the order dated 29th April 2004, where it is mentioned in the second paragraph that it is, however, made clear that.
Sir, let us read the order.
Yes. The writ petitioner shall not, until further order of the court, enter the school premises till the application being can number 558 of 2004 is heard out finally. It would
This
be open for.
application is modification application.
Yes, madam. It would be open for the petitioner to file affidavit in opposition or any other party or any other parties in the matter may file the affidavit in opposition. This shall be done within a period of fortnight. Reply thereto, if any, filed within 1 week from the after the summer vacation. The matter will appear in the list after summer vacation. Now, kindly see it. It is, however, made clear that in the event this application fails, then the petitioner shall be deemed to have joined the school in terms of the instruction given by the TI on and from this day. However, the officer in charge of the local police station without the leave of this court cannot take any steps for the time being, since the matter is sub judice. The writ petitioner shall write a letter of apology to the school for trying to join the school without any appointment letter in writing. Then kindly come to page 44A.
So this you wanted to join on the strength of page 66.
44A, this is the order dated 5th October 2005.
In that application.
Kindly see. None appears on behalf of the petitioner. This is application for modification by order dated 22nd July 2003. No ground has been made out for modification of the order as the learned counsel was present when the aforesaid order was passed. Moreover, I find there is hardly any affectation of the petitioner of the order dated 22nd July 2003. As such, the application is dismissed.
Now,
there will be no.
22nd July 2003 is which order?
22nd July 2003. This is a order whereby 62 and 63, whereby the 62 and 63 order passed in contempt jurisdiction, where there is a direction to register the name of the petitioner upon the DI concerned. Page 62 and 63.
No.
62 and 63, whereby the district inspector school is directed to register the forward the name for filling the post after taking preliminary examination.
So that has culminated in the direction for after 62, 63,
66
decision has been taken.
Yes.
DI said appoint him for compassionate appointment in your school in a group D post.
Yes.
In any vacancy.
In any vacancy, then the school preferred modification application. That was also dismissed.
Very good. Then what happened?
2009 up to 2009, petitioner could not join in the school in the instance of the school authority. Then filed a fresh writ petition seeking appointment. Then 2009, the order, kindly look to order impugned once. There is all reasons are mentioned in the order. Page 109. This is a order dated 19 June 2019. May I read? Order. The petitioner seeks appointment on compensation ground in accordance with an order passed by the learned single judge of this court on 29th April 2004. The parent order was passed by the learned single judge on 29 January 2002. This order, it was noted internally.
Just 29 January order to
29 page 57.
That is an order in contempt.
No, page 59 is the order whereby the direction was given by the Honorable High Court to consider the case of the petitioner within 6 weeks.
Yes.
Then,
Yeah.
yes.
So you preferred the writ petition for implementation of page 43.
43.
That he shall be, it is made clear in the event this application fails,
Yes.
you will be deemed to have been
Joined in the service from the day. And the order attains finality. The school authority never filed any appeal. No application has been, the order attains finality now. And kindly see page 109. The reason.
Now it was ultimately dismissed on page 44A.
A, modification application.
That, no, that is dated. What is the date of this order?
5th October 2005.
5th October
2005.
This page 44A.
44A.
Modification application dismissed.
Dismissed.
So his modification application was against
The order, recommendation order of the DI. Appoint him in any post. Page 66 order. After the order issued by the district inspector.
That is a modification of application for modification of
The order. No, 22nd July order. School authority was silent over the matter. Subsequently, DI passed an order of appointment. Then they filed the application for modification of the order. Dated 22nd July. The order passed in contempt jurisdiction.
Page
22nd July order. 62-63.
That is 22nd July.
July.
Acha, modification application was for 22nd July order.
Yes. Page
63.
62 and 63.
By which it was directed that school will take a decision.
And register the name of the petitioner in the direct and highness category.
Now school said, it was said that it will be open to the school to take a decision. So where is the compulsion? There is no compulsion.
But the modification application.
No, this was to a school says, as well during the group C, it will be open to take a decision whether the post should be, which post? This is the post of clerk. So the school said that I cannot fill up the post of clerk because it has already been filled up. So the modification in fact becomes immaterial. Suppose it is not modified, then the school's decision has attained finally that there is no. Now the next problem is that page 66, the DI
66.
Now it is did you file writ petition for implementation of this order?
Yes.
Where is that writ petition prayer?
Writ petition.
Court is saying that you have preferred the writ petition for implementation
Yes,
of
yes, yes, just-
29th April 2004 order.
Kindly see page 35, prayer B. 35.
2009.
2009 writ petition, absolutely. এটাই তো?
To deem the petitioner, where is you want, acha, when did you file the writ petition? Writ petition was affirmed
2009.
2009. So why didn't you pray for implementation of page 66?
That has never been done.
Either.
Admittedly, that has never been done.
Acha, then Mr. Tahole to, acha, come to now page 109. How did the court proceed?
Yes, yes, yes. Kindly see. This court, it was the fifth line. This court,
Heh.
it was noted that interior that the concerned DI had not applied his mind to the admitted position of the application made by the petitioner in the prescribed form. By the said order, the DI was permitted to register the application made by the petitioner in accordance with law within stipulated period of time. The order passed in the contempt proceedings filed by the petitioner dated 29th April 2004 and is replied
That
upon
is page 29.
29th April, page 43. 43, to? 43. Upon by the counsel for the petitioner, the operative portion
Page
of the
টা
43, 29th April 2004,
That is after the DI's order.
after the DI's order. DI's order dated 66,
29 January 2004. Page 66.
page 66.
Where is this 29th April 2000? That is the modification application যেটা বলছি না?
43.
That
Or-
is page 40.
The contempt order. Order passed in a contempt proceeding.
না না, 29th April is a order passed in
Contempt proceeding.
No modification application.
modification application filed in connection with
With
the
contempt application. Here it is mentioned, can number 558,
page 43.
43. Type copy
That
is
is
43A.
you filed a modification application. Modification you wanted of page
Filing modification application, but the order was passed in a contempt proceeding.
that
Application for modification was not considered in that set.
Kindly see there at the top, WPCRC reference
ঠিক
can
আছে,
number
ঠিক আছে।
558 2004.
court contempt filed petitions dated and is relied upon by the
Upon by the
operative
counsel of the petitioner, the operative portion of the order dated 29th April 2004 is set out below. It is, however, made clear that in the event this application fails, then the petitioner shall be deemed to have joined the school in terms of the instruction given by the DI on and from this day. However, the officer in charge of the local police station without the leave of the court cannot take any steps for the time being since the matter is sub judice. The writ petitioner shall write a letter of apology to the school for trying to join the school without any appointment letter in writing. It should be noted that the learned single judge was of the view that if the application made by the school is dismissed, then the petitioner would be deemed to have joined the school in terms of the instruction given by DI council relies on the order dated 5th October 2005, which records inter alia that the application for modification of an earlier order passed by the learned single judge dated 22nd July 2003 was dismissed.
Where is this 5th October 2000?
The dismissal of the
Dismissal of the application for modification 44A, page 44A, 44A, type copy is there.
তাহলে what is the court saying? It should be noted single judge was of the view.
If an application made by
in
the
terms
school
of
is
the
dismissed,
Instructions given by
instruction given by the
in terms of
DI
the
council
instructions
relies on the
given by-
order.
Wait.
Yes, 44A, kindly see.
Acha, what was the instruction given by the DI?
That is not mentioned in the order.
No, then come to page 63.
63.
Page 62, it states direction was upon the school to take a decision.
Yes,
If the post is required to be filled, then it should be sent
Not.
to the DI Now, what is this DI's instruction? Council relies in terms of the instructions of the DI council.
DI instruction is at page 66. This is the order.
Oh. It is a request. DI returns a request, page 66. This is not a deduction.
Now kindly come to internal page 2 of the impugned order. Yes. It should be noted that the learned single judge was of the view that if an application made by the school is dismissed, then the petitioner would be deemed to have joined the school in terms of the instruction given by the DI. Council relies on the order dated 5th October 2005, which records inter alia that the application for modification of the earlier order passed by the learned single judge on 22nd July 2003 was dismissed. Council submits that the reason of the order dated 5th October 2005 and in terms of the direction contained in the order dated 29th April 2004, the petitioner should be deemed to have joined the school. The council also relies on a communication from DI dated 12th January 2004, which is at page 66, by
Yes.
which the relying on two orders passed by the learned single judge, the concerned school was requested to appoint the petitioner on compassionate ground in any vacancy of the school, preferably in vacancy of clerk. Then kindly come to page internal
Yeah,
page 3.
Mr. Chatterjee,
Yes.
where is that order saying that your name is incorporated in the roster?
Yes, kindly see. Just a minute. Page.
Where did you show us
Page
that?
50,
61, na?
61.
page 6. No. Page
Yes,
52.
yes,
টা দেখো তো।
61.
Just a minute. Page 61. Yes. 5th February 2003. Appointment in the post of non-teaching staff of any DA-getting schools.
So after this, you waited for 9 years, na?
No,
Yes,
this is the order
yeah.
dated 5th February 2003. Thereafter.
No, this contempt application which you filed thereafter.
And the order
was
is
for violation of which order?
violation of the order dated 29 January 2002. Page 57. The order starts.
Okay, page 57. Why did you, page 57 said, page 57 direct the DI to register the aforesaid in accordance with-
Application in accordance with law deal with the same, if the same was made within the
So
time.
that was done on 5th of February.
February.
Then why did you prefer the contempt?
Contempt has been preferred against this said order for non-compliance.
What is the non-compliance?
Compliance has been done.
Eh?
Compliance has been done on record.
What is the non-compliance?
No. The petitioner preferred a contempt application. In the contempt application, there is a direction for upon the school authority.
29 January 2002.
After, why was the contempt filed?
The violation of the order dated 29 January 2000.
What was the violation? The DI will do it and he will, if refused, he will intimate the reason. What is the violation?
In the order,
Acha, there was a direction upon school. No,
in
that
the
was
order,
for,
in the order, there is a two part regarding retirement benefits,
yes. but
provident
what
fund,
is the-
gratuity, contribute.
Acha, what was the violation of the school?
Probably, my lord, the benefit has not been given. Kindly see, it is submitted,
Oh,
Mr. Basu, that the deceased employee was not entitled to any pension from the government.
This was
Page
communicated to
July.
the learned advocate.
Oh,
Kindly see page July 22nd, 2003, second paragraph order. Second, it is submitted by Mr. Basu Choudhury that this deceased employee was not entitled to any pension from the government. Therefore, I direct the DI to
all right.
intimate
Now,
the
now kindly come back to the order, page 111.
111.
Now, council appearing for
The
this
council appearing for the school relies on several documents annexed to the report filed on 17 June 2019. Report ache, report ta পাবো। From which it appears that the TI had written the advocate representing the state inter alia that the petitioner's name will be forwarded for consideration for appointment in the post of non-teaching staff in DA school as and when opportunity will be available. The council further
that is
relies.
page, that is page 61.
61.
Yes, that is the
61.
Yes.
The council further relies on earlier order dated 22nd July 2003 passed by the learned single judge of this court, which indicates inter alia that the post of clerk is still vacant in the concerned school and that it be open for the school authority to take a decision whether the post should be filled or not. The council relies on the other document to show that the vacant post of the clerk has already been filled by one Robi Binani and there was no other vacant post of the clerk left in the school. Council also point to a letter dated 12 January 2004 from the DI to the concerned school which states inter alia that the petitioner may be appointed on compassionate ground in any vacancy of his school, preferably a vacancy of clerk. Despite several orders have been passed by the court, including orders dated 15th May, 16th May 2019, the state is not represented. Having heard the council appearing for the petitioner and the school, and the court cannot permit the school or DI to disregard the effect of the order passed by the learned single judge of this court on 29th April 2004, read with the 5th October 2005. Since the modification application filed by the school was dismissed in October 2005, no further ground remains for refusing to appoint the petitioner on compassionate ground.
But this modification application was not for the letter of 29th April 2004.
Modification application filed subsequently after the order passed by the DI to appoint the petitioner. Page 66.
Yes, 29th April 2004 modification application was kept pending.
That was dismissed.
Dismissed.
That is 5th of October 2005. So where is your modification application?
That has not been annexed in the stay application.
Then what did you want for modification? Because this modification was passed in contempt. This is not a modification you sought for the order of the DI at page 63.
No, absolutely. After the order passed by the DI, immediately they come to the court with the modification application.
How will we know that?
Page 60, kindly see page 66 once.
Page 66 is the 12th of January 2024.
24. And the modification application is filed, kindly 44.3.
Oh.
2004, can number 558 of 2004. Only 12 these days.
Application
এই অর্ডারে বলে দিব যে যেহেতু ইনস্ট্রাকশন আমরা এইটাতে has again যেটা হচ্ছে they shall be deemed to have '24 2004 order.
No, I
No.
wanted
22nd July order.
22nd July 2003.
That is contempt order.
Yes.
That is the content order, but in the contempt order directing to register his name.
কোথায়? To take a decision. School was directed to take, it will be open to the school to take a decision whether the post is to be filled up or not.
And has been taken.
That is why the DI. Now you will take a decision whether you will appoint him to the post of clerk or not.
Yes.
That modification you wanted. There was no necessity for that ought to have been filed by the
No necessity to file any application on because the school has taken a decision and intimated.
decision.
মডিফিকেশন তো চেক অর্ডার খেয়ে গেছে 2004
But in the order, your lordship will find that is
That is the DI order of page 61. You
Page
wanted
61.
more.
that is the melody contempt proceedings in violation of the order dated 29 January 2010.
এইটাতে বলেছে আমি রেজিস্টার করে দিচ্ছি ওর নামটা ফরওয়ার্ডেড হবে ফর অ্যাপয়েন্টমেন্ট ইন এ
That is the case order.
So you wanted modification of page 61 by which the DY said that I am incorporating in the roster and he will be appointed as and when vacancy occurs in any DA getting school. So you applied for modification that DA getting I have no vacancy
Modification application টা আছে তো?
because
আছে।
by a letter of 12th of January 2004, the DI has requested you to appoint him to the post of clerk or in a group D post.
এইখানে should have stopped here আমার ভ্যাকেন্ট পোস্ট নেই এইটার পরেও ওই মডিফিকেশনটা প্রয়োজন 2003 এর ডিআই এর
সেটা বলো কবে করেছে
that is in melody
ইনফরমেটিটার লাইনটা ধরো তাহলে উড়িয়ে দেবো খারাপ লাগছে লোকটা এত বছর ধরে লিটিগেশন করছে।
Page 66,
2016 পর্যন্ত এই রিপোর্ট এবার কোর্টের ফলে ডিসমিস করতে should be clean.
And kindly see page, kindly consider page 112 once, the further direction upon the DI by the Honorable Single Judge.
Yes.
Since second line, since the modification application filed by the school was dismissed in October 2005, no further ground remains in refusing the appoint the petitioner on compassionate ground.
Where he will appoint?
Kindly see the subsequent
Huh.
lines. Two communication dated DI dated 5th February 2003 and 12th January 2004 further reinforces that the petitioner should be appointed in the concerned school since it has
Wrong.
been submitted by the council.
This is wrong. Where in page 61, page 6, in the page 12 January 2004,
66.
Mr. Chatterjee,
Yes,
there is DI has said that I am requesting you.
yes.
There is no direction. You are hereby requested to
To
appoint.
appoint. Yes. And
In
kindly see
any vacancy of the school, preferably in the post of clerk. Clerk vacancy was filled up. Now, did you have any group D vacancy?
no, that has also been filled up.
Where do we know that?
That is subsequently that has been filled up by the order of the DI. At present, there is no vacancy either in the group D or the clerk.
So when was it filled up? Vacancy in the post of group D.
and there is a subsequent direction also since it has been submitted by the council appearing for the school that there is no vacancy in the post of clerk. This court deemed it proper that both the DI as well as the school should be directed to take expeditious steps for appointment of the petitioner in any post of non-teaching staff in this concerned school. Since there have been no subsequent development after 2004 disentitling the petitioner from the stand.
Since it has been submitted by appearing for there are no vacancy, this submission is being made in 2019.
19.
No vacancy in the post of this court deems it proper that both DI
as well as school should be directed to take expeditious steps for appointment of the petitioner in any post of non-teaching staff in the concerned.
When was this direction given? 2019.
This is an impugned order direction given in the impugned order.
Should be, since it has been submitted by the council for the school, there are no vacancy. Both DI and school should be directed.
Should be directed.
Then what happens? Since
there have been no subsequent development after 2004 disentitling the petitioner from the stand taken by the DI, this court deemed it fit to direct the DI to act in terms of the letter issued by him on 12 January 2004 so that the petitioner can be considered for appointment in the concerned school in any appropriate vacancy. The concerned authorities will be at liberty to verify the eligibility of the petitioner of the concerned post. The entire exercise should be completed by the DI within 31st July 2019 and the petitioner be deemed to have been appointed from 29th April 2004.
So what is the direction? Considered for appointment.
Consider for appointment.
Is there any direction that appoint?
No, but the vacancy.
If there is a vacancy, you consider, and if there is a vacancy and he can be put in that post, his appointment will be deemed to be from 2004.
But we don't know whether the vacancy is there or not.
So you, Mr. Jana, what is the direction? Courts, this order, why you are aggrieved? By this order, you have been directed the concerned The concerned authority will be at liberty to এই যে this court deems it fit. Got it?
Concerned authority will be at liberty.
না না again উপরে this court deems it fit. This is the direction now. This got it? First, second, third, fourth, fifth, sixth, seventh, eighth line.
Direct that DI.
This court deems it fit to direct the DI to act in terms of 12th January 20 so that the petitioner can be considered for appointment in the concerned school in an appropriate vacancy. The concerned authorities will be at liberty to verify the. So, direction is upon DI.
DI.
So, why you are aggrieved by this order?
I am aggrieved by the lawsuit, the last 4 lines. The entire exercise should be completed by the DI within 31st July. Petitioner be deemed to have been appointed.
Yes. Now, what the DI will do? DI will ascertain from your pay, from your staff pattern, whether there is at all any existing vacancy or not. This order was passed in 2019. Now, if ultimately a decision is taken,
Without any, ultimately DI comes to a conclusion that the
there is no vacancy, the person will die.
29 January 2004 deemed to have been appointed.
That we will consider. But the person is fighting since when? Tell us.
1998.
98.
That's
98.
Your lordship, if your lordship did not consider the course order, there is no vacancy, there is no scheme for completion appointment.
No, you cannot take that point. That point you cannot argue because that point you argued in the year 1998. Your council argued. Kindly come to the first order. You cannot take your point now. And there is no direction upon you to appoint. It is upon the DI. If the DI gives, what is your problem?
No, I have no problem.
Then what is your problem?
That is the DI equality to any suitable vacancy. So any school, any DI getting school. If the DI considered his case, that I have no problem. But that should be considered that is deemed to have been appointed since 29 April without any war.
How will you appoint if there was no vacancy in 2000? You have to bring your staff pattern before us.
That is that I have to present staff pattern. That
Yes, from staff pattern starting from 1998. Entire staff pattern has to be brought. It is very easy to reject a person's claim. Today you are arguing, Mr. Jana, in 30 years after the writ petition was filed. Oh, no, there is no provision of compassionate appointment. Why were you sleeping when DI said in 2001 that incorporate his name in the DI roster? DI के बोली DI roster तक जो केसটা রেকর্ড আমরা ডিআই কে কি বলবো বাই দিস তাহলে ডিআই কে বলেছিল ডিরেক্ট করেছিল ডিআই কে টু অ্যাক্ট ইন টার্মস অফ দ্য অর্ডার অফ 12 জানুয়ারি স্কুল যদি বলে হুম ডিআই তো অ্যাক্ট করেনি ডিআই হ্যাজ শো দ্যাট who you school do not have to pay money for his appointment.
No, so salary being paid by the school of
What salary you pay?
delegating school.
Notional fixation will be given. তোমার তো ডিএও তোমার you don't have any pension also.
That is the you will also can see next page 113
Page
of the judgment.
113.
And he paid his salary on that basis. That is my
And the petitioner will be deemed to be appointed from being the date of the
You are paying.
That's why school is agreed.
School will pay provided the DI takes a decision that there was at all any vacancy in your school. What we are reading, come to the 8th line, try to understand. This code deems it fit. Got it? Deems it, please apply your mind. Deems it fit to direct the DI to act in terms of the letter issued by him on 12 January 2004, so that the petitioner can be considered for appointment in the considered school in any appropriate vacancy, full stop. So first it is to DI to take a decision as to whether there is any appropriate vacancy, whether he can be placed in the same or not. Very good. Then if he finds that in the school there is a vacancy, then this concerned authority will be verify his eligibility. And then if he ultimately succeeds and is appointed, then that appointment will be from 2004. There are 3 stages.
That's it. And if it is considered that the petitioner ultimately,
So ultimately we are at this stage.
then appointment be deemed to have been appointed from 29.
Sir, রাজাই জন্মালো না রাজত্ব বলছে first let him become entitled.
If the DI melody considered his melody case and they find that he is eligible, then 29th April be paid the salary on that basis.
That is because the order of page 43 remains unassailed. Modification application order is unassailed.
44A.
এই পয়েন্টটা বলেছিল
43 melody, that is still melody application for modification was kept pending.
কোথায় kept pending? Page 45.
44A, type copy.
44A dismissed.
44 is dismissed.
তাহলে a modification application is dismissed.
Advocates also not present.
Modification application dismissed. আর কি রইলো? তাহলে what attains finality? Page 43. What is page 43? That shall be deemed to have joined in terms of the DI notification. So you cannot have any grievance as regards that.
29 April.
এই পয়েন্টটা এখানে কোথায় যেন আর্গু করেছিল যে কম্প্যাশনেট এবং ডিএগেটিং স্কুলে হয় না, তোমার চোখে পড়েছে?
Kindly see the page. Yes, that is there.
He argued that
Yeah, yes. The respondent authority also argued. আমাকে একটু 29 জানুয়ারি রয়টা দেখুন। Yes, 57 তো।
এইটাই বলে দিচ্ছি।
Kindly see page 57, order dated 29 January 2022.
আসো
Last portion.
At 59.
At 59 also. Yes. Yes. Obligement.
কোথায় পান কোথায় আমার লোকটা কোথায়? কে ছিল আগে? হ্যাঁ, তোমার পরে কি আছে রোস্টারে?
মইনাসকে ডাকো না ফোন করে।
কটা অবধি তোমার? Page
The order passed in this appeal.
date
22nd January 2020.
22nd January.
Yes. 2nd January 2020. 22nd January 2020.
Younger দিয়ে কি বলেছে? প্রেজেন্ট আসো।
Item number 12 and 13 was called in the first call. And Mr. Jana is there, my lord. If you also kindly fix it, my lord.
Date cannot be fixed, Mr. Sen.
It was, my lord, appearing in the list as 2 p.m. fixed method.
2 p.m. fixed matter. Then it
Mr. Jana
has
is
to,
there, my lord.
Mr. Sen, then it has to go after vacation.
Lord, I tell you, only
So
one,
it
one,
is
one,
better.
one second, 1 second.
Mr. Sen, it is better let it remain its position. If it is not reached prior to the vacation, you remind us after vacation, we'll fix up a date and here. এই কি আছো ফোনটা ফোন করছিলে
জিজ্ঞেস করছি
গভর্নমেন্ট সার্ভিং আপনি কি সরকারি চাকরি করেন হ্যাঁ কোন মামলায় এসেছেন আপনি
वो मेरा मामला सर सेकंड हाफ में है
পড়েন
सेकंड
Item number 28.
Your Lordship, I want to mention this matter. This is an original side assigned matter assigned before this bench. Your Lordship, I'm mentioning this for the fourth time for the inclusion in the list.
We will release it, madam. What can we do? We made an endeavor to see if it can be solved. Cannot be done. What can we do? Hand over the slip. এই original side next দিন উপরের দিকে রেখে বলতে তাহলে what was the matter about? Did we hear
It
it?
is a work of property matter. It is related
It
to a
has
work
been assigned before which bench?
before this bench, Your Lordship.
এটা কি দেখি
এটাতে
what you are saying, madam?
Your Lordship, this bench only. It has been, I think, incorrect mentioning slip has been done, Your Lordship.
Yes, call the list.
May your Lordship's kind leave to mention item number 28 of my Lord's days list.
28.
28. This
Yes.
matter was being heard extensively by this honorable bench. Your Lordship will recollect Mr. Joydeep Kaur was addressing on a point of issuance of a no objection by the West Bengal Housing and Infrastructure Development Corporation. And Mr. Arindam Banerjee
We
was
will release it, sir.
kindly do not release it.
It is not possible, sir. We
I
won't be
understand.
able.
But kindly do not release. I'll take my chance.
No, we will release it, sir. No use. You try before another bench. আসো এই ফাইলটা বের
Lordship
করে
had
দাও
heard
তো।
it extensively, my Lords, will kindly.
Sir,
Don't
we
beat me up.
understand we made an endeavor, but what can be done? We cannot unnecessarily hold you back, no?
But I'll
দেখি
take my
আমার
chance before
ফাইলটা
this.
দাও।
Lordship will kindly not release. I'll take my chance before this.
No, don't take your chance, sir. You will.
But my intention was not to get the matter released. my Lord.
No, not for that. We are not annoyed with you. We understand the problem. We heard it, but what can we do, sir? Today
Kindly do not
we are
release. Kindly
we
do
are pressed with another matter of Mr. Joyanto Mitro, that Mr. Ghosh was appearing. Huh?
Kindly do not release. Well, I'll wait for my turn.
You tell Mr. Joydeep Kaur, all right, when you are junior, you are mentioning we will not release, next day we will release.
I'm ready.
Yes, remind us, yes, call this, call.
My lord,
Item number.
my lord said that my case will be released if it is not resolved by today. So I have given my acceptance, but they have taken time. So my prayer is kindly record.
Matter is in the list.
Is in the list 24, my lord. My lord said it will not be called.
Acceptance in the mail.
If it is not resolved, I have given acceptance to their proposal, but they have taken time. I have got the mail yesterday at 7 p.m., 7:30 p.m.
Item number 24.
Oh. So
What
my
has
lord,
been done? What has
my
happened?
prayer is that before releasing, my lord, my submission may be recorded. It is there in the email itself, my lord.
এ আমরা কবে
হলো না হলো তো
আচ্ছা এটা 16 তারিখ টু বি মেনশনড এর টপে দিয়ে দাও। On 16th, it will be at the top of the list. We will record it, we will release it. Yes, call the matter.
I'm for that. It's told that Honorable Advocate General will appear virtually. If not, I will start. If he join, I will.
কল করছেন থাকলে
We want to have a talk with you.
Oh, my lord, he will. I have a talk with at 1:30, my lord.
No, no, Mr.
I will
kindly-
start, my lord. My lord, sorry, my lord.
You have filed a recalling app.
My lord, my lord.
What was our order in contempt? That there was a possibility that they will be regularized. A possibility, no, there were riders to that effect.
Now, my lord, if his lordship takes this application,
We
recalling,
take the application.
my lord, recalling,
What was the argument all throughout?
my lord, that,
Give us some time, give us some
my lord,
time.
that's the, I, My lord,
Let us try to understand. We have recorded even many time was taken.
my lord.
Ultimately, Mr. Mukherjee, upon written instruction, said that we will. Now, sir, if the government decides that I will not implement, suppose today is your recalling application, whichever way we will pass order, either we can pass order against them, forum will be open for it. And if we pass order against in your favor, forum will be open. So how long these people will fight with you?
Now, my lord, so far this main issue is, my lord,
How
which has-
long, sir? Try to understand.
I am-
You are
I am
our officer.
Yes, my lord, I
You
am,
are not. We are not having an antagonistic
No.
relationship.
no, my lord, certainly not.
Suppose today, if the government, upon adopting a policy decision, decides this is going to go a long way, the poor litigants will not get the.
Now, my lord,
If you say that yes, that there is a, Mr. Bosumolli, you know the court procedure. Today, if your recalling application is allowed, they will be aggrieved. They have a higher forum. And if we reject it, you will be having a higher forum. Now, who will be suffering? Tell us.
no, my lord, I have fully agreed with his lordship. The problem is, my lord, the certain facts, my lord, which has not brought to the notice of this lordship.
So your officers are very adamant. They say that no, now new facts have to be
No,
brought.
not new fact, my lord. All these employees, my lord, I will show from
Where
this
is the
recalling.
advocate general? Let us
Please,
we want
I
to.
just give me 1 second. Let me call and I just ask. He
No,
told me that
we want him to intervene.
he will.
He is the
Yes, my lord.
advocate general.
will-
We want him
Lord,
to
I-
intervene. How long these people will go along?
I
with
had
the-
I had a talk at 1:30 and I just explained him this matter and he says, my lord, I will appear virtually. So, my lord, may I just call him and come back, my lord.
বলতে চাইছি কেন ওরা ইয়েটা চাইছে
কেন কি তুমি যে মাথাতে What do you say, Mr. Ghosh?
But I've challenged the maintainability of the recalling application. The recalling application in either of the
Let us understand your mindset. What you are intending. We will go into the recalling. No problem with that. Now, do you want us to intervene and ask the Advocate General to look into the matter? Because that will be again time consuming. We want to understand your mindset.
But if
Because
you
this is the 5th occasion or 6th occasion.
Yes, my lord.
We want to do the matter.
Well.
So, but the thing is, if we enter into a dialogue with the Advocate General, now he will say, then I will let me go through it.
Yes, definitely. But my prayer before your lordship today is, my lord, kindly decide the recalling application and dismiss it. Let the contempt proceedings be
Dismiss, my
gone
lord,
on.
that's not merit, my lord. That's
Yes,
what has
please.
fallen from his lordship.
But let the contempt application be gone. But Learned Advocate General may intervene any time in the
So far the
contempt.
recalling is concerned, my lord, that is.
All right, Mr. Bushman.
But I have challenged the maintainability point of the recalling application. because this is not an application under Order 9 Rule 13. There is no provision in the Code of Civil
All
Procedure.
right, let him start. It is his.
Yes.
Yes.
Now, my lord, his lordship kindly takes, my lord,
Yes. Tell us which order you want to recall.
my lord, the order dated, order of his lordship, my lord, 7 December's order, my lord, that I have annexed, my lord.
7 December.
My lord. 7 December 2023, my lord. That is at page, my lord. 20 is the single bench order. I have annexed.
এই একটু বের করে দাও না কোনটা বলছে
20, page 20. Starts with page 20, my lord.
নিয়ে নাও
পেজিকে একটা ফোন কর না। না যাস না। 7 December 2023. 20, page 20. পিজি সাহেব লিঙ্কে আসেনি, বলে দিলাম তো আমি। জবাবে আমাকে।
Yes.
I have set out the order, my lord. The single bench order as well as his lordship's order. Single bench order is at page paragraph 4 and paragraph 5 is his lordship's order, my lord. I have set out the portion of his lordship's order, my lord.
Yes.
Now, my lord, kindly come to paragraph 6. By skipping over this order, my lord, kindly come to paragraph 6. In view of the above direction of the Honorable Court.
No, let us go through the order. 11th April.
Yes, my lord.
So against that order, paragraph 4, they preferred an
This appeal before his lordship. আমাকে বলবে লিঙ্কটা পাঠিয়ে দিতে।
Yes, paragraph.
Paragraph 5 is I have set out the order of his lordship. Paragraph 4 is the single bench order. And paragraph 5 I have set out the order of his.
Now, what was the stand of this is the principal secretary to
Judicial
judicial department said.
My lord.
Proposal is for absorption and the proposal for amendment.
Order paragraph 5. Page 6.
Policy decision. Accordingly, the anti-corruption department has been initiated for obtaining concurrence on policy decision. Say the file is still therefore still premature, which I had already taken a different incorporation. Yes, paragraph.
Paragraph 6, my lord, starts with paragraph 6, my lord. In view of the above direction, the Honorable Court, it shows that the Judicial Department, Government of West Bengal has made an endeavor to provide better prospect to the contractual employee of so and so. But since the issue of absorption on contractual employees is a policy matter of the state government and not exclusively within the domain of the Judicial Department West Bengal, the same is still at a premature stage and the impugned draft notification could not be finalized. Now, my lord, paragraph 7, my lord, I have explained The one by one, my lord.
Impute draft notification was
Draft notification. Yes, my lord.
proposed amendment of service. Kindly come to paragraph 6, paragraph 8 of the principal secretary's affidavit. It may be further some main essence of proposed amendment of service rules
My lord.
is for absorption, and the proposal for absorption implies huge financial implication and also having major policy decision.
Lordship, state government regarding absorption.
This was not your stand earlier. Your stand earlier was that the district legal services authority is not giving us the approval.
Now, my lord.
Let us understand
Yes,
that was
my lord.
now very good. Now kindly, now this proposal was kept in it was being processed. It is not that full stop has been there.
No, no, my lord.
Now,
Now, my lord, now what happened is, my lord, in paragraph 7, lordship will start, my lord. May I just read, my lord?
Yes.
7A, lordship. The contractual employees of so-and-so have entered into such employment with knowledge of conditions mentioned in notification bearing number 2013, in which it was inter alia mentioned.
How can you take this ground in recalling?
Now, my lord, this has
point was available to you when the main matter was
Lord,
being.
this was not pointed out before his lordship at
So
the
that
time
is
of,
your fault.
at the
If
time,
it
my
was
lord,
not pointed out, it is
Lord,
your
at the-
laches.
yes, but at the time, my lord,
Sir, it is a well settled proposition. A thing which you could have argued at the time of hearing,
my lord.
you did not take.
No, my lord.
That's very good. This is one of your grounds.
Now, my lord,
Yes,
kindly takes, come to page 28 once.
please complete that.
Yes, my lord. Sorry, my lord. To 1 year or till regular filling up of the post as per recruitment rules, whichever is earlier. There may be an express condition inter alia in the contract that such engagement will not be regularized in future in any manner whatsoever. Copy of the said notification, that is at page 28, but kindly takes page 28 once.
Page 28.
8, my lord.
Yes.
Now, Lord, kindly takes, my lord. Filling up 288 post DLSA Salsa West Bengal. The governor has been pleased to fill up 288 number of contractual basis against the sanction post only on the basis of examination already conducted. Now, my lord, 288 numbers of post will be filled up on contractual basis for a period of 1 year or till regular filling up of the post as per recruitment rules, whichever is earlier. There may be an express condition inter alia in the contract that such engagement will not be regularized in future in any manner whatsoever. This was not pointed out at the time when the matter was taken up by his lordship. This was not shown to his lordship that these employees has been engagement in as a absolutely as a contractual basis, and they will not claim Miller regularization.
They will point out because you took the decision of draft rules. It is your secretary who has taken.
But now, Miller, I have also said, Miller, the step by step. Now, Miller, next, Miller, the contractual employee are not appointed against any post. They have no lien to the post. They have no right to any pay scale attached to the post. The appointment and continuance of a contractual employee is at the discretion of the employer. Contractual employees do not have any right for regularization. Next, Miller, the contractual employee in the case was made aware of their terms of employment. Having accepted such terms, the contractual employees cannot claim absorption on regularization. Specimen copy of appointment letter is annexed to your kindly takes page 29, Milord, the appointment letters. The appointment letter, one of appointment letter I have annexed, Milord. Kindly takes, Milord, the name of the candidate is Ujjwal Das. His appointed as learned assistant cum cashier. Pay, consolidated pay, so-and-so, Salsa, Jongipur, Murshidabad. Next page is, Milord, the above named candidate is clearly given to understand that his appointment against the above post mentioned against his name is purely temporary and on contractual basis for a fixed consolidated pay only without any other allowances noted against his name, and his said service may be terminated at any point or any time without any prior notice. This was also not pointed out at the time of hearing of his lordship, before his
No,
lordship.
please answer one.
But I am.
I may be wrong.
No, my lord.
I am answering these. You are absolutely right. This was not pointed out.
No,
Why it was not pointed out? Because you yourself said that I have framed the draft rules.
That's, my lord, that's precisely, my lord. Now, my lord.
So that is one aspect.
My lord.
Yes. What more you want to point
Now,
out?
my lord, now, my lord, kindly text, my lord. These are the, my lord, I have stated everything, my lord. Now, say if lordship come to step by step, this is now, my lord, H, the 7H, my lord. Kindly take
7H.
H, my lord. The endeavor of Judicial Department of Government of West Bengal.
Yeah, yeah.
My lord. My lord. Bad. The endeavor of Judicial Department, Government of West Bengal for providing opportunity to the contractual employees of SALSA and DLSA, etc., does not create any right as claimed, and the Judicial Department, Government of West Bengal has no authority to conquer such right till finalization of the notification, which is premature.
The endeavor of the Judicial Department for providing opportunity to the contractual employees does not create it. This is a good ground of appeal, sir.
In D, lordship,
Yes,
kindly takes D, paragraph D. The draft notification that has been pointed out by his lordship, the draft notification of the West Bengal Legal Services Authority amendment is applicable to the permanent employees of SALSA and DLSA. Finalization of the draft rules.
How it is
How many permanent staff are there in the SLSA or DLSA?
Now, Lord, yes.
How many?
কটা আছে কি বলেছে কি?
No, not a single. Huh?
No, check.
I believe so.
Is there not a single permanent staff?
No, there is a permanent staff.
There's not a single. Permanent staff. There's not a single permanent staff.
Except secretary, which is deputed from the
High Court.
From the judicial service.
From
There's
judicial
not a single
service.
staff.
Oh,
D, lordship, can I take D also, my lord? I have mentioned, my lord, the finalization of the draft rules without settling absorption issue is not relevant to the present context. D. Now, my lord, in paragraph 8, my lord, I have stated, my lord, the step by step, the procedure with regard to rules of business of the West Bengal government, my lord. In the paragraph 8, my lord, kindly takes once. It is also pertinent to mention that the provisions of the West Bengal rules business framed under clause 3 of Article 160 of the Constitution of India, read the West Bengal Secretariat Manual concerning the legislative procedure shall mutandly apply in respect of procedure for finalization of a subordinate legislation. Step by step procedure for finalization of the subordinate.
Who is stopping you? Do it. We are not stopping you.
No, Lord, I have.
That we will deal with in contempt. Now, whether in contempt you will come and take the stand, we will ask your principal secretary. Don't play with fire, sir.
No, I have just tried to explain.
Anything else, Mr. Boswali?
No, this is the.
Anything else, Mr.
No, this is the only submission that I have.
Where is your avowment regarding delay?
Now, my lord, at this stage, my lord, they have given benefits, my lord, what benefit they have given, my lord, that I have mentioned in paragraph page 42 of the my lord, this recalling application. What benefit at this present moment they are getting, my lord? Kindly takes page 42 once, my lord. 41 is the order and the 42 is the benefit that has been given, my lord. This is the latest, and paragraph 8 is there are, as following from his lordship, not only this judicial department, there are other finance and other, thereafter MIC, the CM also, they are also engaged in for the finalization of that, that step by
So
step in paragraph 8.
we are not saying,
I have-
because you yourself said that we are taking those steps. These steps, paragraph 8, which you said, these are the steps you are taking. That is why you said that hold your hand. And we gave you, an,
My lord.
what should I say, an open window. All right, you are saying that we are disposing of the matter. No problem, take your, because we understand it is a policy decision.
My lord.
Question of money is involved.
Yes.
So today, after doing this, if you enkindle a hope in the mind of a person, that sir,
We
we
have,
will
no, my lord, they are
then you
well,
stab him. What?
no, my lord,
This is
they are
a
well
red
aware
flag.
about this fact, my lord, that they will never be regularized. It is well known to them, my lord, as per their appointment.
So who said? I am not disagreeing.
No,
We are
I
not
have-
disagreeing.
no,
You are absolutely right.
I have
Whether state cannot change its policy decision.
at this present moment, I have
Court has
instruction.
not forced you to and compelled you to adopt such policy decision.
Now, my lord, in my reply,
Mr.
my lord,
Bosumoli,
my lord.
what order has been passed based on the submission made on behalf of the
That's
state?
what, my lord.
Don't ask the court to give different treatment to judicial department, financial department.
I have just tried to explain his lordship the facts which has not brought to the notice of his lordship. At that point, if these facts was brought to the notice of his lordship at that point of time, my lord, then situation would be otherwise.
That is your conscious.
But I am not said anything, my lord, since, my lord, it has already been. I have tried to, my lord.
No. We are not blaming you.
No, my lord.
তুমি কি করবে? সরকার করবে না। আচ্ছা, what is your explanation about delay আর কিছু নেই?
Delay, my lord, I have said, my lord, in paragraph 5 of my reply, my lord, I have said, my lord. এটা
Paragraph 5B. Reply.
হ্যাঁ 5B.
Reply কি হবে? Opposition দিলাম না, তুমি reply কোথায় আসছো?
In the application.
Reply তো পরে আসবে।
Yes, my lord.
আসো। The present application being CAN 2 of 2024. What is CAN 1?
CAN 1 is disposed of.
কার কাছে মেনশন করবো রে?
সোমবারই করবো তাহলে, পরশু দিনই মেনশন। ইয়েস, নেক্সট। Yes, Kaushal Kumar. Number 2.
Lordship is the regular bench.
না আমি চেঞ্জ হয়ে গেছি। বসাক সাহেব। I think land. It is land না, Mr. Mitro? I think
Land.
Court Justice Bosak.
Oh yes, your lordship, just yesterday I think
Yes, I'm a new man now.
heavier bench.
Yes, Mr.
Mala,
Yes, sir.
this is called shirking the responsibility.
No.
We would have been
No, we can keep it, but it will go beyond.
we would have been happier, my lord, in this court.
First day, my lord.
What is the violation?
But the order was passed on 6/8/2024, my lord. My lord, mandatory part of the order is 17, page number 17, my lord. That was the direction.
You are appearing for the alleged contempt, no?
No, no.
Oh, no, no. Oh.
Page number 17, my lord, the order was. Order was for 6/8/2024, my lord.
Oh.
Of 8 weeks.
The present contempt application has been papered, alleging violation of new matter, new contempt.
Madam, new contempt, madam. At page 15, madam, the solemn order passed.
This contempt application, your allegation is, we said that you cannot recover 10,000. This what? This page 16.
Yes.
This internal page 2. Direction towards imposition of cost is state.
Madam.
So that has not been taken from you. Cost has not been taken.
No,
from
no,
you.
madam, no. And another, madam.
And respondent number 4 is restrained from deducting the said amount from salary of the petitioner. Then what is the contempt, sir?
My lord, every month, my lord, deducting 10,000 rupees from salary of the petitioner, my lord.
Oh, your salary.
Yes, pay slip.
My lord. I have the slip, my lord, salary slip. Before
Salary
and
slip, annex?
after. No, I shall file my supplementary affidavit, my lord.
No. It don't play with the code, sir. We told you on that day.
I was not present on that day, my lord.
Yes, yes, you were there.
No, my lord. Last occasion I was not, my lord. I was my native place. That is my, my lord.
Prosenjit Mukherjee came.
My lord. he was-
Mukherjee came and
my
said
lord, my
that
lord.
we will.
I
Then
was
why
not,
you are
my lord.
saying?
I was not present, my lord. My lord, 1 week, my lord.
No, no.
Next week, my lord. In the meantime, I shall file, my lord.
The technical ground dismiss to technical ground. Dismiss to the technical ground. One year term. September 24.
On the prayer of the learned advocate appearing for the petitioner, the application is dismissed.
May please, your lordship. My lord,
Yes, yes. Payslip to the show your payslip. Wait, wait. Tribunal said deduct 10,000 by 5 monthly installment. And we have stayed that order and we directed the respondent restraint from deducting the said amount from your salary. So after the communication of this order, was there any further deduction?
My lord, my lord.
When did you communicate this order? 3rd September 24?
My lord.
When did you communicate? Who was the respondent?
The district magistrate, my lord.
Respondent number 4.
Four, my
Who
lord.
was the respondent number 4?
District magistrate and collector of Uttar Dinajpur.
Respondent number 4 in the writ petition.
My lord.
Salary statement. The living period is second. That is September, October, September. October period is 706. Maybe after a few years. The November period is 704. Deduction to কোথায় সেটাই সব 20,700 something.
So where is the deduction?
Where is the deduction?
There is no deduction.
Every month, my lord, 10 rupees, 10,000 deducted. My lord, before passing order, my lord.
Oh, it is your pay slip.
My lord.
Pay slip, your total pay in the month of September. So we passed order on 3rd September 2024. So from September, it would be calculated whether. So September, your salary to 20,703. October 20,706. How about, I don't know whether 3 rupees. Thereafter, November 20,704. December 20,704. January 20,701. February 20,704. Where is the deduction?
There is no deduction.
If any amount is deducted, amount cannot remain same.
See,
before passing order, my lord, the respondent authority, my lord, deducting every month.
How much leverage we will give to you?
Yeah.
Matter was came up 3 months, 2 months ago. We said that we were about to dismiss, you cried. Your senior said, kindly give me. This is the salary. Still you want to keep the matter pending?
Dismiss. Fresh petition.
ওই dismiss টা আগেরটা যেটা দিয়েছিলাম সেটাই
একটা স্লিপে রেখে দিন।
এটাকে রেকর্ডে রেখে দাও
হ্যাঁ,
বেশ।
হ্যাঁ।
Yes, next matter.
Please, your lordship. My lord, on the last occasion, your lordships were pleased to direct me to serve the copy and the affidavit of service, my lord, I am fine. It's a contempt matter, my lord. Your lordship's order, my lord, according to us, it has been flouted, disregarded, and no effect has been given to the order dated 3rd of
কন্টেম্পটা বের করে দাও, সুবিধা হয়। পুরো ফাইল ধরিয়ে দিলে
3rd of October 2024. Thereafter, my lord, we have communicated that, and thereafter contempt notice was also issued. And your lordships on the other day, my lord, upon hearing, fixed up the date today, and affidavit of service, my lord, accordingly has been filed. My learned friend is, I believe he is appearing for the contempt, alleged contempt.
I'm for the contempt, my lord. My lord, I'm late.
National sample survey organized.
My lord, they are the
Direction was upon whom?
upon the respondents, those who are holding the post of the National Sample Survey Organization.
Who are the petitioners in the second writ petition?
They were the petitioner in the second petition, the National Sample Survey.
You're directed to discuss all attachment.
Yes.
My lord, just allotted brief, my lord. I'm led by Mr. Anirban Mitro, my lord.
You're happy to learn that?
My lord, kindly give me, my lord, 2 weeks.
To be present.
Kindly give me, my lord, 2 weeks time to take instruction, my lord.
Person will go on not getting his pension. When was it communicated? Where is your evidence?
26th of October 2000.
Anirban Mitro. Where is Anirban Mitro?
His court number 16, my lord.
Huh?
His court number 16, my lord.
Ask him to come just now. Where is he? Come. Let us see evidence or service.
6/10/2024, a second copy is 2012. 2024, a second.
Contempted কবে?
So what happened? They have not called you, no steps taken.
No, my lord. No steps. Totally stone cold silence.
That was instruction, my lord.
Been engaged, no? So you must have been given some instruction.
Lord, praying for some time, my lord.
Sometime means you have taken a resolution that you will close it at 3:30. Where is your counsel? Call him, go outside, ring him up and tell that court wants his presence just now. Just now, within 10 minutes or we are issuing rule of contempt against your officer. You will have to be personal. Tell him over phone. Yes, password.
Yes,
yes, next.
ও এটা কি না এটা সেই
Huh? So we will dismiss them. What order did we pass?
Last time it was an order for filing an affidavit of reply. Affidavit in reply.
Lordship, the main order.
So tell us what was the main matter, na?
The main matter, your lordship, is regarding family pension.
You are the second wife.
I am the second one.
What is your name?
Order.
Ina Oda. So we said that your marriage is a invalid marriage.
But it is not.
So you have children.
Yes, I have children. Date gulo either date gulo দিয়েছিলাম আর date gulo
Why? On what ground you are seeking review?
ground is, your lordship, as they say, as they say, the departments, the authorities, they say that the marriage is not a valid one. But
No, we said it is not.
But it is that it is valid. It is. The reason behind is after the death of the first wife,
3rd of April 88.
then only Meena Ora got married.
No.
Yes, your lordship. Will kindly come.
If you get married after 1988, how were you given birth to a son?
That is the point. That is the mistake the departments, the authorities, they have done. No, it's 1111 down. No. Will kindly come.
Just a moment. What did you say before us? Let us say. Mr. Niyogi. Mr. Niyogi appeared, na?
Yes, your lordship.
And you wanted but family pension. Since one widow has died, this was your argument. Unless a wife is judicially separated by an order. These are your two grounds argument. One ground was that when the first wife has expired, their duty count to be family. Second ground was since there was no judicial separation, you have a right. You did not argue before us that your son was not born in 87.
That was wrongly. He could not argue in a proper manner, your lordship.
Lordship, the documents that were given to us at the time affirmed by this writ petitioner, Lordship will kindly add on the basis of the dates that your lordships have passed in the order. Now, Lordship, in a review application, there are new documents put forward. Lordship, there are in the Lordship, they have annexed documents from the Panchayat.
Panchayat and the executive magistrate.
They have annexed an affidavit sworn by her during this proceeding prior to passing of the order, which did not come out at that point of time.
Which one?
Lordship, from the review application, if your Lordship sees, there is one certificate issued by the Gram Panchayat dated 24/8/2023 and an affidavit.
24, no.
Lordship sees the review application.
27, there is a document. What is page 20?
Lordship, there is one document dated Lordship will kindly come to annexure R6 of the review petition, Lordship. What they filed now.
Page R6.
Yes, it's not paginated in my brief.
No, what is R4?
Lordship, R4 is R4 is an appeal to the general manager.
Divisional copy of letters of
Lordship, this is a letter dated 26,
25th November 2006.
it's not telling. কোন তারিখ? এটাই তো?
হ্যাঁ, এটাই।
24/3/2009. Lordship will then come to the affidavit, which they are relying upon now, R6, Lordship. This is where the case changes, Lordship.
No, this affidavit filed by you, it is your declaration.
So it was there before
It
the
is your
commitment was passed.
declaration. If
Yes,
you
that
give
is-
wrong declaration, it is you liable to be prosecuted. Don't.
They could have relied upon it before
is-
your
it
lordships
is-
at the time of passing the order.
It is
That
your
is-
declaration given on oath before a notary public or executive magistrate, whatever. So that
Executive magistrate.
cannot be
The
stated.
text is, your
You
lordship.
show the birth certificate of birth of Robi Orao.
Now your lordship will kindly come to the main WPC.
The certificate of birth of Robi Orao,
In that
where you
case,
will,
no, your
you
lordship, in
will
that case,
ask the court to go, court will go, but you show the certificate of
your
Robi.
lordship, I'll clarify on that point. Is at during that time, that is 88.
Again, you are bringing arguments, doing arguments. You are asked to show the certificate of birth of Robi Orao.
No, that birth certificate we don't have, your lordship, because that birth certificate is not there with the lady.
You come to the order.
WPCT, your
You
lordship.
come to
Your
the
lordship
order
will kindly
page.
WPCT. Your lordship will put.
Why should we go to the WPC? Try to answer what my brother is saying.
Yes, your lordship, I understand.
Answer the question.
Come to
The birth certificate.
internal page 6.
Judgment.
Got it? Six line. Robi Orao, son of second wife, was born on 1st January 1987.
It's in my affidavit also. ওই যে ওখানে judgment এ আছে।
Got it? Our order. Got it? Yes. Sixth line. The portion starting with the name Robi Orao. Got it?
Second one.
Robi Orao, the son of second wife, was born on 1st January 1987. It is your submission. Whereas the first wife of deceased employee died on 3rd April 1998.
3rd April 18.
That means Robi Orao was born earlier.
Lordship, how can that be after marriage? The son was born. It was not before the marriage.
Mere oral assertion.
Come to page 34 of your document. Where have you said that you were not born on 87? Page 34, this is your declaration?
This is the declaration. Yes.
You have said paragraph 1, Robi Orao is your son, born from Meena Orao. Got it? Page 36, 34, review application.
My affidavit in opposition has the chart, what was given to us by her. The affidavit in opposition contains the entire chart, Lordship. The
Affidavit in
opposition.
you have filed.
Yes.
Where
Lordship.
is
Not in your report?
opposition? Yes, what you have written?
Lordship, please, I've annexed the documents that were given to us at the relevant point of time, which were relied upon by the CAT. No, the above is there. Those were with the paragraph 4. Lordship, looking at the reply or the opposition? Opposition, Lordship, I've tabulated the entire. It's not annexed. It was annexed in the WPCT. This is no, but relying on the documents that she had given, or not my statement in the sense. That is the problem.
Page 34 is your own affidavit. Where you have said that that is not the date of birth of Robi Ora.
That is
You come to page 4, internal page 4. Have you brought the original application? Or from the tribunal application came, was filed?
Madam, there is
From the tribunal.
agreed by the judgment dated.
No, your lordship, I can satisfy, but give me some time, your lordship. In this, actually, the thing is, your lordship will kindly see the birth date. Your
Agreed by
lordship. The birth date is 1187, 1190, all from the same month, same day.
On
Yes, on 87.
No, that.
1187.
In their opposition.
1190.
It can't be, your lordship. This, how can it
That
be, your
is what-
lordship? And this was not given by that man, that ex-employee.
So who didn't? You were there before us at the.
No, your lordship, this is.
It was submitted by.
No, your lordship, it was not submitted by the
No,
ex-employee.
you come to page 4, internal page 4 of the order. Third paragraph. In your original application, Mina Orao herself declared himself to be second wife of the deceased.
It is her.
In the affidavit filed by Robi Orao,
Yes.
mentioned, declared that his date of birth was 1st January 1987. Court has observed the same. Whereas the first wife died on 3rd April 1988.
Ordered.
Agreed by the order dated.
এটাই তো বলছি এখানে কোথাও লিখেছে
Okay, you have tried your level
We
best.
could ask him each question being the city 125 of
My lord, a poor lady can be injustice, my lord. He was long time, he was his wife and husband is relation, my lord. And this division bench order, my lord, similar nature of case, my lord.
Item number 7, my lord, your lordship.
No, pass over. Oh, item number 7.
The extensively hard if written notes of argument. We'll just hand it over to your lordship. But I have shown it to my learned senior friend also.
Last page, your lordship, kindly. Last
They
page.
teach an
so that-
argument. Yes, my lord.
Last page, your lordship.
For your lordship's control. They came.
No, what you are saying?
No.
We deserve the judge.
No, what is the matter? Just giving
Just what do you want?
Suit for partition. I am the plaintiff who decreed in my favor. Before this honorable court, they have came with certain documents that there are certain other properties. So, lordship, your lordship was of the view to remand the matter before the trial court to a second preliminary decree and give them liberty to file an additional written statement, thereby disclosing that document. And if the learned trial court shall frame a second issues and pass a second preliminary.
Now what happened?
That is the matter.
That is the blood. We suggest to blood.
No, what was the
But other
order did we
other.
pass?
But your lordship.
We have not passed any.
No. Your lordship.
This is a partition.
This is a partition.
During hearing certain
Document.
information here,
But is other
any of you find out that there are
Yes.
some properties
Yes.
which have not been
added.
So where
That
we
should be
have got
considered
that
by
on record?
But they have not filed any application under Order 41 Rule 27. They filed a supplementary affidavit before your lordship.
Before your lordship.
Yes or no?
Yes, Lord, kindly see page
Yes, your
11 of my
lordship not-
notes. Kindly see page
giving
11.
the-
Page 11, the last paragraph. And after giving all details, not only, however,
The suit was decreed.
yes, in preliminary form, in my favor.
In any
Form.
Where is your application? Say supplementary paid করে দিও ওর ভেতর থেকে supplementary
আমি
ওই যে উনি ফাইল করেছেন পেড করে
May I just give you also the last paragraph. However, without prejudice to the case made out herein above, considering the nature of the suit and without interfering the judgment and preliminary decree impugned herein, dated 16 December 2016, the defendant may be permitted to file an additional written statement, if so advised, thereby categorically disclosing any other joint properties. And the learned trial court may be directed to frame additional issue to that effect and determine the share of the parties in respect of the same by passing additional second preliminary decree.
So we are in fact saying that you will bring this property by way of an additional written
Yes.
so that it happens.
Without interfering the judgment yourself.
Learned advocates appearing for the learned advocates appearing
My lord, with folded hands, I am saying, my lord, I couldn't appear because I was on legs, my lord. Your lordship kindly. My lord, kindly, my lord, kindly.
Online.
Already I am scared, my lord.
Scared for whom? Of the court or myself?
My lord, that time your lordship says, my lord, in anticipation, I may have to appear in this matter. Out of the court, I am saying. And your observation is.
Person who will give you relevant person. Who is the relevant person?
Relevant person.
Mr.
Okay,
Mitra.
দেখো, Miss-
Relevant person.
Mr. Dube আছে বোধহয়, দেখো, who is the relevant person? আরে আসুন এখানে।
Officer is present.
Some of the officers are present.
Then, yes, madam, who is there?
আরে বলুন, who is the relevant person?
থেকে এরা দেখছি
Who is the relevant person? Oh, contemners are not here. But
Okay, contemners along with do not deal with the file.
no, that I
We are
understood.
dealing with the file. They are all employees of National Sample Survey Organization.
My lord, according to them, my lord, ministry is the competent authority. Man, I don't want to go to that arena. My lord, your lordship kindly gives us.
The officer. Who is the other sir?
Go against him, sir.
Is there contempt?
Who was the
Contempt?
The list
You
are
have
given.
completed all the. You have not completed any from anyone.
এইখানে কে responsible বলুন?
Rita Singh Rathod, Chief Executive Officer, Solil Kumar Mukhopadhyay, Additional Director General,
The order was on the
NK Tutu, Director,
From Delhi.
Manish Anand.
They will be the contemner.
মিনিস্ট্রি সেক্রেটারি আছে
What you are saying, sir,
Then we'll
your jobs will be shattered.
পিটিশন সেক্রেটারি
Your lordship kindly grants 2 weeks time. Your lordship kindly take instruction. Kindly allow me to take instruction. জানেই না কিছু বোঝেই না কি হবে বুঝতে পারছো যে আন্ডার সেক্রেটারি এলে my lord, kindly allow 2 weeks time, my lord. Let me take instructions, my lord.
Why, sir, you are not disbursing pension. We will stop your pension before stop your salary finished.
My lord, kindly.
There must be a limit.
My lord.
High Court division benches passed an
My
order.
lord, absolutely.
Go to the Supreme Court.
My lord, absolutely. My lord, kindly give me 2 weeks time, my lord. Kindly give me 2 weeks time, my lord.
Mr. Mitro, your chief executive officer will problem.
I understand, my lord. I understand, my lord. I remember, my lord. Being an officer of the court, my lord, I very candidly submit. Your lordship kindly gives 2 weeks time. Let me try to sort out the matter. Otherwise, I will retire from the brief.
Record that you are going to comply with the order. File a compliance report before us. File a compliance report.
My lord, to take instruction, my lord, I have to take I understand what is passing on your lordship's mind. I understand.
The persons who are dealing with the file are in court. It was not their responsibility to tell you that, sir, we are in this problem.
Absolutely,
What is
my lord.
happening, sir?
Absolutely, my lord. Kindly allow some time, my lord, to take instruction. My lord, at least 10 days time, my lord.
Mr. Mitro, learned advocate. If he does not get the pension, we will take appropriate steps against your officers and tell her to be ready. We will stop her salary. If she doesn't get it, she doesn't get it.
Grateful.
Mr. Mitro, take it up.
My lord.
But may I request your lordship?
আবার
Not
কি request?
not only humble request, because
we have,
শুক্রবার
we are-
the last mile your lordship, that would be for our. My lord, only request, my lord, the queue to be maintained because my lord will be sitting after, my lord, I think 14-15 days after. So my lord, up to 5, it has done. Then my lord, our matter is 8, 9, 10, 11, 12, 13, 14. So otherwise, my lord, if it remains at the same, my lord,
don't know কি উপরের দিকে কিছু আছে না?
my request only to grateful, your lordship, grateful.